sure that we reassure every working American that they have a right. They have a right to a safe workplace. Madam President, with that, I yield the floor. And note the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
that the calling of the quorum be suspended.
Without objection.
Madam President, members of the Senate, I have the privilege of, over most of my tenure in the United States Senate, serving on the Senate Finance Committee and working with a good Senate leader like Senator Baucus. And I now have the privilege of serving on there, but not as ranking member or chairman, but just as a member. But I compliment Senator Baucus for his leadership on this whole business of tax reform and holding hearings that he's having held. And today a very important one's being held on the question of, is the distribution of tax burden and benefits equitable? The topic of today's hearing is very appropriate. Whether the distribution of tax benefits and burdens is equitable is a very important topic. However, I would argue that there is a more important question that we should be debating. And we should be answering this question: what is the purpose of the federal income tax? We can't talk about whether taxpayers are paying their fair share if we don't know why we want them paying taxes in the first place. We're in a situation now where people are talking about increasing taxes on higher income people because supposedly they can afford it, and probably they can afford it. But I get sick and tired of the demagoguery that goes on in Washington, not just by members of Congress, but by too many people, that higher income people ought to be paying more taxes. According to the Joint Committee on Taxation's latest analysis, 49% of the households are paying 100% of the taxes coming into the federal government, while 51% are not paying any income tax whatsoever. Now, how high do taxes have to go to satisfy the appetite of people in this Congress to spend money? And particularly, how high do marginal tax rates have to go to satisfy those clamoring for higher taxes from the wealthiest? How high to satisfy you, and you know who you are? There's an article by Investor Business Daily that I want to refer to, that according to this article, even if the government confiscated, we're not talking about taxation of a certain amount of income, but if it confiscated all the income of the people earning $250,000 a year or more, the money confiscated would fund the federal government today for a mere 140 days. And you know what you would have? You wouldn't have those people trying to maximize their income, because why would you maximize it if the government's going to confiscate it? So that's a very basic question to how high do taxes have to go to satisfy the appetite of people in this Congress to spend money. Funding the government should be one of, if not the, primary goal of income tax laws. And of course that leaves out this whole business of whether the federal government's purpose is for the purpose of redistributing income. Note here that I am specifically focusing on the income tax. This is because payroll taxes are not used to fund the government. Social Security and Medicare taxes are, in fact, insurance programs. And because they're insurance programs, the taxes they pay are insurance premiums, because individuals who pay them expect to benefit when they reach a certain age. It is clear that some believe that the tax code should be used to reduce the growing income disparity between the lowest and highest income quintiles. This assumes a key objective of the federal government through the federal income tax laws should be to ensure that income is distributed equally throughout our citizenry. In other words, these folks actually believe that the federal government is the best judge of how income should be spent. That is not what our founding fathers or original authors of the tax laws intended. In addition to considering the purpose of tax revenue, in fact, we ought to have some principles of taxation that we abide by. These principles of taxation would be a much stronger foundation than the day-to-day decisions about whether or not we ought to raise taxes on a certain number of people. So I abide by the principle that's been a fact of our tax laws for 50 years, that an average of 18.2% of the GDP of this country is good enough for what the government needs to spend. And I say that because a 50-year average, it hasn't been harmful to the economy, as we've seen this country just expand and expand and expand economically over that period of time. And quite frankly, it ought to be clear that 18.2% of the GDP of this country coming in for us to spend is not a level of expenditures that taxpayers are revolted against. So we take in that 18.2% for 535 of us to decide how to spend. The other 82% is in the pockets of the taxpayers for them to decide how to spend or to save, and quite frankly, how much to spend and how much to save. Because if the 18.2% of us, or any amount more, comes to 535 members of Congress to decide how to divide up the resources of this country, we would not have the economic growth that we have of our economy when 137 million taxpayers deciding how to spend or how to save and how much of each decide how to do it. The economic growth of this country is enhanced tremendously because of the dynamics of the free market system. And if we were going to go the greater route of increasing that 18% very dramatically, we would be moving increasingly towards the Europeanizing of our economy, and I think that would be very bad. In evaluating whether people are paying their fair share, experts frequently look at whether a proposal improves the progressivity of our tax system. Critics of lower tax rates continue to attempt to use distribution tables to show that tax relief proposals disproportionately benefit the upper income. We keep hearing that the rich are getting rich while the poor are getting poorer. This is not an intellectually honest statement, as it implies that those who were poor stay poor throughout their lifetime, and those who are rich stay rich throughout their lifetime, and that's just not the case. I want to quote about this point from a 2007 report of the Department of Treasury titled, quote, Income Mobility in the U.S. from 1996 to 2005. I quote the key findings. There was considerable income mobility of individuals in the U.S. economy during 1996 through 2005 period, as over half of the taxpayers moved to a different income quintile over this period. Next, roughly half of the taxpayers who began in the bottom income quintile in 1996 moved up to a higher income group by 2005. Next, among those with the very highest incomes in 96, the top 1/100th of 1%, only 25% of that very small group remained in that group in 2005. Moreover, the median real income of these taxpayers declined over this period. Next, the degree of mobility among income groups is unchanged from the prior decade, meaning the prior study by the Treasury Department. And that period of time was 1987 through 1996. Lastly, economic growth resulted in rising incomes for most taxpayers for the period of 1996 to 2005. Median income of all taxpayers increased by 24% after adjusting for inflation, and the real incomes of two-thirds of all taxpayers increased over this period. In addition, the median incomes of those initially in the lower income groups increased more than the median incomes of those initially in the higher income groups. End of quote. Therefore, whoever is saying, and we hear it every day here on the floor of the Senate, that once rich, Americans stay rich, and once poor, they stay poor, is purely mistaken. And Internal Revenue Service data supports this analysis. The report on the 400 tax returns with the highest incomes reported over 14 years shows that in any given year, on average, about 40% of the returns were filed by taxpayers that are not in any of the other 14 years. In other words, 40% of those people that are in the highest brackets are not in the highest brackets ever in that 14-year period of time. So once rich, not always rich. I welcome this data on this important matter for one simple reason. It sheds light on what America really is all about: vast opportunities and income mobility. But built by immigrants from all over the world, our country truly provides unique opportunities for everyone. These opportunities include better education, health care services, land, financial security, but most importantly, our country provides people with the freedom to obtain necessary skills to climb the economic ladder and live better lives. We are a free nation. We are a mobile nation. We are a nation of hardworking, innovative, skilled, and resilient people who like to take risks when necessary in order to succeed. Bottom line, we have an obligation as lawmakers to incorporate these fundamental principles into our tax system instead of just talking about, are the rich paying enough? I yield the floor. It's the absence of a quorum.
The senator from Texas.
Madam President, I'd ask unanimous consent to speak for up to 20 minutes.
Without objection.
I thank the chair. Madam President, I rise to speak on a nomination that's pending before the Senate, and I do so with some degree of trepidation because, as someone who has been a member of the legal profession for about 30-plus years, I really believe it's imperative that I voice my strong concerns and indeed my objections to the nomination of Jack McConnell to become a United States District Judge, a vote we'll have tomorrow morning on a cloture vote. The reason I was attracted, like so many others, I think, to law school and the legal profession was because of the majesty of the notion of the rule of law, its importance to our democracy, the responsibilities that lawyers owed not just to themselves to enrich themselves, but to their client, the fiduciary duty that a lawyer has to represent a client. And then, of course, the ethical standards, which some might scoff at, but which actually work pretty well, that keep lawyers, for the most part, accountable to the high ethical standards imposed by the legal profession. But unfortunately, and I I'm sorry to have to say this, but the hard truth is Mr. McConnell's record, which I will describe here in a moment, is one of not upholding the rule of law, but perverting the rule of law, ignoring the responsibilities that he had to his client, and manipulating those ethical standards in order to enrich himself and his law partners. But first, let me just say that Mr. McConnell, when he came before the Senate Judiciary Committee, intentionally misled the committee during the confirmation process. I don't know how I can say it any more gently. The fact is he lied to the Senate Judiciary Committee during this confirmation process. And regardless of who nominates an individual, party affiliation aside, I don't think the Senate as an institution should tolerate a nominee that intentionally misrepresents the facts in the context of a confirmation process. This involved his participation in or involvement with a set of stolen confidential documents that his law firm obtained during a lawsuit against the Sherwin-Williams Company. In 2010, his answers to written questions to the committee, Mr. McConnell told members that, quote, I would not say I was familiar with the documents in any fashion, close quote. Only a few months later, in September 2010, this same nominee gave a deposition in an Ohio court where he testified that he was the first attorney at his firm to review the documents in question, that he had drafted a newspaper editorial citing information that had come from those documents, and that portions of those documents were incorporated in a brief filed under his signature. Despite this obvious contradiction, and given an opportunity to correct his misleading statement, Mr. McConnell has unequivocally stood by his original statement to committee members. I would reiterate, Madam President, this body should not approve or confirm a lifetime appointment to someone who wants to serve as a judge in particular, but anyone who would lie to or at best intentionally mislead the Senate by downplaying his role in a serious controversy involving, in this case, stolen confidential documents. Now, during the time I practiced law and served on the state court bench in my state, in Texas, I've come to respect lawyers who handle all sorts of cases, lawyers that prosecute criminal cases, lawyers that defend criminal cases, lawyers that defend citizens, including companies, sued for money damages, and those who bring those lawsuits, constrained, again, by the rule of law, duty to the client, and high ethical standards. But based on his long career as a lawyer, Mr. McConnell has advocated, it's clear from the evidence, a results-oriented view of the law and manipulated it for his personal gain. These theories that he's advanced and ostensibly on behalf of his client have been rejected not just by people like me, but by a very broad range of opinion in the legal community. For example, Mr. McConnell and his firm sued paint manufacturers based on an unprecedented theory of public nuisance that allowed them to circumvent long-standing legal doctrine and receive a huge jury award in a sympathetic judge's courtroom. Ultimately, the Rhode Island Supreme Court rejected unanimously this theory, declaring it at odds with centuries of American law and antithetical to the common law, to quote the court. As one Iowa Attorney General, who happens to be a Democrat, said, Mr. McConnell's lead paint litigation was, quote, a lawsuit in search of a legal theory, close quote. Mr. McConnell's lead paint litigation scheme required the complicity, unfortunately, of state and local officials, a practice that I'm going to speak on more in just a moment. But Mr. McConnell's reaction to the decision of the Rhode Island Supreme Court also demonstrates his lack of judicial temperament, something very important, particularly for a judge. It showed that not only does he still adamantly believe in these radical, unprecedented legal theories rejected by the highest court in Rhode Island, but he also lacks the temperament to serve on the federal bench. Instead of respecting the decision made by the highest court in the state, Mr. McConnell wrote a strident op-ed piece condemning the court and stating that he believed that their decisions, quote, let the wrongdoers off the hook, close quote. In other words, Mr. McConnell made clear that he believes the law should be manipulated to serve his agenda, not to uphold the rule of law, and nor to respect the very bodies that are responsible under our system for interpreting the law and rendering judgment. Mr. McConnell's outburst was not particularly surprising, given his public admission previously that he is, quote, an emotional person about injustice at any level, personal, societal, or global, as he put it, close quote. This lack of temperament and novel view of the law is indicative of the type of judge that Jack McConnell would be. I'm sorry to say, biased against a certain class of people and untethered to the rule of law. Mr. McConnell's practices are also exist under an ethical cloud throughout his career. He and his law firm made billions of dollars and a name for themselves through their pioneering practice of soliciting no-bid contingent fee contracts from state officials. For example, Mr. McConnell and his firm played a central role in litigating lawsuits brought by state attorney generals, first against tobacco companies and then lead-based paint manufacturers. Of course, I'm not saying that tobacco companies and other companies shouldn't be held accountable for harmful products, but the purpose of the law should be to compensate those people who have been aggrieved and to deter others from acting in the same fashion in the future. And the litigation that he constructed and devised, the scheme that he literally created, did none of that. The question is, ultimately, where did the money go? Under these contracts, Mr. McConnell and his partners have repeatedly sued American businesses, pocketing billions of dollars for themselves in attorney's fees while leaving taxpayers on the hook for the resulting costs. In the word of one respected legal commentator, Mr. McConnell and lawyers like him have, quote, perverted the legal system for personal and political gain at the expense of everyone else, close quote. In several lawsuits, Mr. McConnell and his partners received contingent fee contracts from state officials to whom they later contributed tens of thousands of dollars. Now, I think there's a lot of very important public policy reasons why state officials should not be able to outsource their responsibilities to private lawyers based on a contingency fee where their only incentive is one of a profit motive, untethered by the sorts of checks and balances that elected or other appointed government officials would ordinarily have. Our system of justice relies on financially disinterested officials who take an oath to uphold the law, and not those whose sole motive is not to uphold the law, but to twist it and to manipulate it in order to maximize their economic gain. Some of these lawyers, including Mr. McConnell's firm, have pocketed what amount to hundreds of thousands of dollars per hour for their work in lawsuits against tobacco companies. Mr. McConnell and lawyers like him are the big winners in these lawsuits, taking home large sums of money that rightfully belong to the taxpayer, the client that I mentioned at the outset. Imagine if these billions of dollars were spent on cancer research or improving public health instead of lining the pockets of a few well-connected, politically well-connected lawyers. More importantly, however, the outsourcing of suits to create private trial lawyers to private trial lawyers on a contingency fee basis creates both the appearance and the opportunity for corruption by allowing state officials to reward their friends and campaign contributors. Now, one reason, Mr. President, that I've taken such a strong personal interest in this issue is because of my service as Attorney General of Texas, following that of Dan Morales, my predecessor. Mr. Morales served over 3 years in the federal penitentiary attempting to illegally channel millions of dollars in a tobacco settlement that was due to the state of Texas, but he steered it to a lawyer friend of his by trying to backdate a contract to make it appear to be something it was not. The actions of Mr. McConnell and his partners by funneling tens of thousands of dollars into campaign accounts of state officials who hired them raises concerns about pay-to-play dealings. In the state of Washington, for example, Mr. McConnell and members of his small South Carolina-based law firm contributed $23,200 to the re-election of the Attorney General in the state of Washington. By the way, that was the very same lawyer who hired them on a contingency fee basis to represent the state. In North Dakota, Mr. McConnell and his wife contributed $30,000 to the gubernatorial campaign of the Attorney General who appointed him as Special Assistant Attorney General for purposes of representing that state in tobacco litigation. Mr. McConnell and his law firm contributed an additional $73,000 to that same Attorney General's state political party during the campaign cycle, making them the number 4 campaign contributor to that organization. Now, there's nothing wrong with people contributing money to political candidates or parties or causes that they believe in, but it's another matter when these contributions are made in connection with no bid, contracts, or apparent political favors. It's no small matter that Mr. McConnell has a lucrative ongoing financial arrangement as a product of his previous work as a trial lawyer. In fact, he will receive $2.5 to $3.1 million a year through 2024 as part of his payout for his work in the tobacco litigation that I mentioned a moment ago. $2.5 to $3.1 million a year through 2024. For anyone that would praise Mr. McConnell for giving up a successful legal career in order to serve as a federal judge, remember that he would be reaping huge windfalls at the expense of taxpayers long into his tenure as a federal judge. Now, some senators will say that whatever his past, Mr. McConnell deserves the benefit of the doubt, and that he would be an impartial judge if confirmed by the Senate to this lifetime appointment. Mr. President, I cannot agree, and neither does, by the way, the United States Chamber of Commerce. They have taken an unprecedented step of opposing this nomination, and, Mr. President, I would ask unanimous consent that that letter be made part of the record following my remarks.
Without objection.
The multiple controversies surrounding Mr. McConnell's nomination are so extraordinary that the Chamber has taken this unprecedented step of opposing his nomination and declaring him, quote, unfit to serve, close quote. In fact, this is the first time in its 99-year history that they have opposed a district court nominee. My colleagues have asked me whether I believe that Texas businesses and business people would get a fair shake in Jack McConnell's courtroom, and I absolutely do not believe they could. To my colleagues who may doubt what I'm saying or look for some proof, I would just say read the record. I'm convinced that you would have trouble looking your constituents in the eye and telling them that you believe that Mr. McConnell would be fair to all litigants in his courtroom, and in this case especially businesses who may be sued for money damages as he did throughout his legal career. In fact, Mr. McConnell, during the Judiciary Committee deliberations, described his legal philosophy as saying that, quote, there are wrongs that need to be righted, and that's how I see the law, close quote. Well, that doesn't cite any applicable legal standard, doesn't actually take into account law as we know it, but just wrongs that he believes need to be righted. Similarly, Mr. McConnell has said that based upon his experience, he has absolutely no confidence that certain industries will ever do the right thing, and that they will only do the right thing when they are sued and forced to by a jury trial. Now, given his tendency to view lawsuits against businesses as a movement against societal injustice, it's difficult to see how Mr. McConnell could put those personal views aside and to give all litigants in his courtroom a fair trial, a right to which they are guaranteed under our Constitution and laws. And I believe a vote to allow Mr. McConnell's nomination is a vote to create yet another court where trial lawyers will repeatedly prevail in frivolous litigation against American businesses, and that's something we ought not to allow. Mr. McConnell's behavior during his career and confirmation process demonstrates a lack of ethics and temperament necessary to serve as a federal judge. I would hope that President would never appoint someone like Jack McConnell, but apparently everyone makes mistakes, including this nomination by this President. Instead of stubbornly digging in his heels, usually the President has agreed to withdraw nominees whose confirmation process produces extraordinary controversy. But since he has failed to do so here, the President has forced me and others to stand our ground and to fight Mr. McConnell's appointment to the federal bench. Based on his deeply troubling ethical record and poor judicial temperament, and the fact that he intentionally misled, if not lied, to the Judiciary Committee during his confirmation process, I believe we must fight this nomination with every tool at our disposal. Mr. President, I yield the floor and note the absence of quorum.
Clerk will call the roll.
Mr. Akaka.
consent the call of the quorum be dispensed with.
Without objection.
Mr. President, as senators know, last night Majority Leader Reid was forced to file another cloture petition on a federal judicial nominee. That's the fifth required to be filed during President Obama's term in office. In this case, it's on Jack McConnell, who's nominated to a vacancy in the United States District Court for the District of Rhode Island. I am concerned that we have to file cloture on judgeships that should simply have an up or down vote. I would hope we're not going back to the situation we had when President Clinton was here and my friends on the Republican side of the aisle pocket filibustered 61 of his nominees. We tried to change that in the 17 months I was chairman during the first 2 years of President Bush's term, and notwithstanding the precedent we had of nominees being blocked by the other side for President Clinton, in that 17 months I moved 100 of President Bush's nominees through the Senate. In the remaining 2.5 years, I think Republicans in charge, they moved another 101. So we tried to change what had been an unfortunate procedure. I hope we're not going back into that. In this case, Mr. McConnell has a strong support of his home state senators, bipartisan support from those in his home state, and his nomination has been reported favorably by a bipartisan majority of the Senate Judiciary Committee, not just once, but several times. And, of course, it's been stranded on the Senate's executive calendar for months, stalled by objections, Republican objections to proceeding to debate and vote. Vote yes or vote no. When you try to block a vote, you're actually voting maybe. People in our state didn't send us here to vote maybe. They expect us to have the courage to vote yes or no. In fact, it's interesting, Mr. President, a few years ago, Republican senators argued that filibusters of judicial nominees were unconstitutional, that every nominee was entitled to an up or down vote. Gave great, strong, moving speeches to that effect, and then, of course, as soon as President Obama got elected, they filibustered his very first judicial nominee. Unsuccessfully, I might say, but they've stalled many others. With these filibusters, the Senate's Republican leadership seems determined to set a new standard for obstruction of judicial nominations. I can't recall a single incident in which a president's judicial nomination to a federal trial court, the federal district court, was blocked by a filibuster, not for Republican presidents or Democratic presidents. I came here, the President of the United States was Gerald Ford, whose statue we just unveiled in the rotunda. We didn't filibuster any of his federal district courts. We didn't filibuster any of President Jimmy Carter's district courts. We didn't filibuster any of Ronald Reagan's federal district courts. We didn't filibuster any of President George H.W. Bush's district courts. We didn't filibuster any of, on the floor anyway, it did in committee, of President Clinton's, or any of President George W. Bush's. Somehow the rules have changed for President Obama. It is troubling as chairman of the Judiciary Committee, but also troubling to the federal judiciary nationwide, why this one president get singled out for this kind of treatment. I did a little research. I went back, as I said, I've been here 37 years, but I went back over the last 6 decades. I found only 3 district court nominations, 3 in over 60 years in which cloture was even filed. For 2 of those, the cloture petition was withdrawn after procedural issues were resolved. For a single one, Senate vote on cloture was invoked, and incidentally, all 3 of those nominations were confirmed. I would hope that nomination of Jack McConnell also be confirmed. As I said, for some reason, I talked about the presidents I've been here with, President Ford, President Carter, President Reagan, President George H.W. Bush, President Clinton, President George W. Bush. But for some reason, the rules seem to have changed for President Obama. Republican senators have applied a heightened and unfair standard to President Obama's district court nominees. Senate Republicans have chosen to depart dramatically from the long tradition of deference on district court nominees to the home state senators, both Republicans and Democrats, who know the needs of their states the best. An unprecedented number of President Obama's highly qualified district court nominees have been targeted for opposition and obstruction. Democrats never applied this standard to President Bush's district court nominees, whether in the majority or the minority. And certainly there were nominees of the district court put forth by that administration that were considered ideologues and would never have been nominated by a Democratic president. All told, in 8 years, the Judiciary Committee reported only a single Bush district court nomination by a party line vote. We Democrats opposed Judge Holmes' nomination strongly, but we did not block it from consideration in the Senate. We said we'll vote up or down. He wasn't filibustered. He was confirmed without the need for a cloture vote. Again, suddenly, with this president, they're applying standards never applied to a president before. Somehow President Obama is being treated differently than any president, Democratic or Republican, before him. Regrettably, Senate Republicans seem intent on continuing the practices they began when President Obama first took office, engaging in narrow partisan attacks on his judicial nominations. They started, as I said before, with his very first judicial nomination, David Hamilton of Indiana, a 15-year veteran of the federal bench. President Obama nominated Judge Hamilton in March 2009 after consultation with the most senior and longest-serving Republican in the Senate, Senator Dick Lugar of Indiana, who then strongly supported the nomination. The President went and nominated somebody supported by a Republican senator, in fact, the most senior Republican senator here. And rather than welcoming this nomination as an attempt by President Obama to step away from the ideological battles of the past, Senate Republicans ignored Senator Lugar's support. They caricatured Judge Hamilton's record. They filibustered his nomination. And only after that filibuster was rejected with an overwhelming vote of 70 to 29, Judge Hamilton was confirmed. Vote of 70 to 29, Judge Hamilton was confirmed. Now, the same Republican senators that just a few years ago protested that such filibusters were unconstitutional, as soon as President Obama was there, that principled stand disappeared. They abandoned all they said they had stood for, and they joined together in an attempt to prevent an up or down vote on President Obama's very first judicial nominee. In other words, The standard they said should be applied to every single president in the history of this country. Every single president in the history of the country, the standard they said should apply, suddenly is changed when this president comes in, and then they want to change the standards. Makes you wonder what it is about President Obama which makes them want to change the rules for him, rules that existed for every president prior to him. I wonder what could be the difference. Since the filibuster of Judge Hamilton, Senate Republicans required the majority leader to file cloture on 3 more highly qualified circuit court nominees. Of course, that's a far cry from Republican insistence that every nominee is required by the Constitution to have an up or down vote, or even from the extraordinary circumstances Republican senators now claim to be the basis for a filibuster.
The senator has used his 10 minutes.
Mr. President, I'd ask consent for 5 minutes more, and I know there are other senators waiting to speak.
Without objection.
There are 13 judicial nominations on the calendar that Democrats are prepared to consider. Each of these nominations should be considered without unnecessary delay. If we do them, we could reduce the judicial vacancies to 80 for the first time since July 2009. In this case, we have an outstanding lawyer, Jack McConnell. The President's nominated him 3 times. He has more than 25 years of experience as a lawyer in private practice. He has the strong support of both Rhode Island senators. Individuals and organizations across the political spectrum in Rhode Island have called for his confirmation. The Providence Journal endorsed his nomination by saying that in his legal work and community leadership, he's shown he has a legal intelligence, character, compassion, independence to be a distinguished jurist. And leading Republican figures in Rhode Island support him. Now, some oppose him because he successfully represented plaintiffs, including the state of Rhode Island itself, in lawsuits against lead paint manufacturers. Now, some here in the Senate may be wanting to support the lead paint industry. I support those who want to go after the people who poison children. That's what Mr. McConnell did. He seems to be punished because he wanted to stand up for children. Well, I'll stand with the children against those who try to poison them with lead in their paint. Mr. President, I appreciate the courtesy of my colleagues in giving me the extra time, the distinguished senior senator from Delaware, the distinguished senator from Connecticut, and I yield the floor.
Mr. President.